Benvenuti in Famiglia contro l'ordine pubblico, il podcast del progetto di ricerca PRIN Social Parenthood, genitorialità sociale, indagine sul fenomeno e sui limiti di ordine pubblico. Noi siamo Stefania Piaperrino, Valentina Cavani e Matteo Caldironi, assegnisti di ricerca delle Università di Milano Bicocca e di Modena e Reggio Emilia. Con voi esploreremo i temi della famiglia, delle persone e della riproduzione sotto la lente del diritto. Dialogheremo con esperti, accademici, giornalisti e professionisti per comprendere come il diritto regola la famiglia e incide sulle proiezioni familiari e genitoriali. Il diritto interviene in tanti settori e su molti fenomeni. Lo fa pure con le persone, le formazioni sociali e la famiglia. Interviene sulla famiglia talvolta proteggendola e talvolta limitandone la Costituzione e o la protezione entro l'ordinamento giuridico italiano. Buon ascolto! Ciao e benvenuti in una nuova puntata. Io sono Stefania, la vostra host, e oggi avremo un episodio un po' particolare. Sono a Denver per presentare il progetto Social Parenthood alla conferenza della Law and Society Association. In questa frizzante città del Colorado ho incontrato tante persone e tante menti brillanti, tra cui la nostra ospite di oggi, Elizabeth Stuart Perry. Per questo la nostra conversazione sarà in inglese. Dunque, enjoy! So, let's talk about our special guest. Elizabeth Stuart Perry is an associate professor and lecturer at the Department of Law at Uppsala University, but her career is quite astonishing. She graduated in biology at the University of Chicago, and then she took her GED in law at the Duke University. And then she graduated again in legal science at UMIA University. She was a lawyer in LA, and now she's an associate professor at the University of Uppsala. Hello, Elizabeth.
Hi, Stefania. And I'm not sure if it's associate or assistant because I usually just use a senior lecturer, but yes, I work in Sweden in academia, which is very different from the family law that I was practicing in LA before moving. So, it's exciting to be here at this conference with you. Beautiful Denver and all that. So,
thank you for taking the time to be here. So, let's dive in. As you know, our podcast delves into family law, and modern family structures, especially the controversial one, based on consent and specific functions. Can you walk us through the family setups in Nordic countries?
Sure. I think, like we were speaking about the other day, the things that are unique about Nordic families, like in Sweden and Finland, and Norway and Denmark and Iceland, the things that are unique, or at least the Nordic peoples are proud to say characterizes their families, I would say are maybe three things. One thing is that children are extremely important in terms of their unique individual citizenship and rights, children's rights under the United Nations Convention on the Rights of the Child. So it means that the entire Nordic region together wants to lead the way in efforts to promote the welfare of children and young people, young adults. So I think there's an emphasis on that even in the family law, because ensuring that children get to participate in things like divorces and even in legislation that concerns them is really important to Nordic peoples. So that's one thing. Children are very important. I would say a second thing is that marriage is playing formal marriage is playing a decreasing role in what people consider important for a family. You know, the important thing for a family is the commitment to each other, whether or not that's formalized with the wedding. And I think that a lot of people, the majority of children are born actually to non-married parents. However, that doesn't mean that they're not living together, they're not dating, they are cohabitant families. And then usually they have a wedding after the first one or two children when they have the time to have a party and really kind of celebrate. So that's the second thing, cohabitation. That's pretty common, right? In other, like in Italy too?
Also in Italy, yes. Family is not based on marriage anymore.
No, yeah. It's kind of a modern families of all kinds. And then I guess the third thing would be this model, which has been through the decades of social democratic political rule, but starting in the maybe 1930s, 1940s, it's been this progression towards women in the workforce, and then increasingly in the 60s and definitely 70s, we had the push of men in the home. So the idea is that you have 2 caregivers for children and caregivers for the home, and 2 wage earners, people who are earning the income outside the home, and therefore they're full partners. And I think there's a Swedish idea that you shouldn't have love based on dependence, private dependence. Everyone should have their own protection from, in relationship to the society, but then in the home, this meeting of 2 equals that help each other and complete each other's lives is an ideal. So that's how families are structured. Now there is kind of a progressive side too, which questions sort of what we call heteronormative, one woman and one man, and so we do have a lot of families that are trying to form new ways. That's another thing, and that's valued by the mainstream culture, I would say.
Okay. Mm-hmm. So let's talk about the elephant in the room. In Nordic countries, who count as a parent, and who's the legal parent, who's the legal father, who's the legal mother?
Right. I guess it's kind of an elephant because this can be controversial. For one thing, the legal mother is definitely the woman who gives birth. That's that Roman law idea. I think we share it in Italy and Sweden, yes, about the mater est presumption. So that's not even written in, for example, in Sweden's föräldrabalk, or the Swedish parental code. It's just it's understated, or it's just assumed, and the code instead begins with paternity and defines who the father is. The only thing it says about mothers actually right now is that egg donors are not the mother. So it implies that the usual case, the normal head rule, is that the woman who gives birth is the mother, and that used to be not problematic. But now we have families who are interested in using surrogacy, who are going abroad and using surrogacy. Of course, egg donors, but that was solved by that statutory clarification. But yeah, so now we have these contests between mothers who give birth and mothers who are the intended mother, or the genetic mother, or both. So who are the fathers? That's what we really have regulation about, and we have a provision about the spouse of the woman who gives birth is presumed to be the father or parent. So if it's another woman, so that has been equalized by gender, since there is marriage equality, or 2 women can get married, 2 men can marry. And then, so there's the presumption, and then there's also the majority of births, of course, because I said they're not 2 married couples. So that takes care of married couples, but for the unmarried couples, the father has to consent, has to recognize, sign an acknowledgement of the birth. And this has just been modernized to be electronic, as long as they do it within the first, I think it's 2 weeks or so, after the birth. And then after that, the social services have a responsibility to come looking, to see who is supposed to be the father to this child in the public records. And then there are some families that don't conceive the old-fashioned way, maybe have trouble with that, and so they seek medically assisted procreation. And for that kind of medical assistance from the Swedish healthcare, often, for that it is there are special provisions in that parental code that talk about who at what point the consent needs to be and how the consent needs to be. But as long as there is consent by the partner of the woman who is being treated to conceive, if the child results from that, then that parent is a legal parent, the second parent, as well as the mother. But we don't allow surrogacy, so it would always be the mother's giving birth.
Okay, so in the code, in Nordic countries, we have the father who is presumably the husband or the one who recognized the child, and then the mother would be the gestational mother. However, we have this other area of laws that are taking into consideration reproductive medicine. So in that case, we consider consent,
Yes.
and we do not consider code. Is it right?
We consider consent, but the consent is in the code. In other words, the consent, the code says, one must sign a consent, and then that parent who has, signed the valid consent becomes the parent. So it's both. I mean, it is regulated. And then, of course, it's regulated across the private family law and the public medical law.
Yeah.
Yeah. And the things about genetic integrity, like, the freedom of information for the child who is born of donated sperm or donated eggs, that they have a right when they reach a certain level of maturity to find out that they are conceived in that way, so they have an idea of their genetic origins. That's their right in Sweden under the statutory code. Yeah.
Okay. So what does happen if someone undergoes banned procedures like surrogacy abroad? If I go abroad and have surrogacy, and then I want to go back to Sweden or Norway or other countries, can they seek recognition of the status filiationis in Nordic countries?
Right. So they do seek recognition. The Nordic countries. So I was giving Sweden as a specific example before about the parenting codes, but they're fairly general. I mean, generally the same. I would say that the various Nordic countries have that statutory structure that has, as does Italy, the same basic ways to become a parent. And then there's the question of adoption, which is another way to become a parent we didn't mention yet. And sometimes that's international, and you're coming back into the country. But that is more accepted, that there's been a properly executed adoption, and then we do recognize, the adoption, or do the adoption in the Nordic country. But with the surrogacy, it involves a going around the state policy that doesn't really approve of surrogacy, and so it's a de facto problem of a couple coming home with a child who they want to be recognized as legal parents, but from that setup, the legal setup that we just discussed, the legal parent would be that woman in another country that gave birth, and the father would be, if she's married, that her husband. And so often there isn't a problem because of all the international agreements about recognizing a genetic father.
Okay.
That's in place in order to make sure that children have, child support and so on. But the mother, as we mentioned, isn't regulated. So that's more difficult, and there has been kind of a resistance to recognizing mothers. However, on the other hand, you have a baby with no other parents, and so, for example, in the Swedish case law, it's been decided different ways. It was denied a few years ago, and then in 2020, we got these cases from the Supreme Court of Sweden saying, actually, because of the child's right to family, we should, in this case, where adoption is not an option, step-parent adoption is not an option, because the two intended parents have now separated, and the father doesn't want the mother to have motherhood. So, that's complicated. And so there was no legal path provided in Swedish law, and the Swedish Supreme Court, to their credit, said we have to do something for the child, and we're going to have to be a little bit almost common law about this. We have to find a way to so we're going to recognize the foreign judgment, and they recognized a judgment from the United States where the legal parents were these intended Swedish parents.
For clarification, I need to ask you, what happens in order to arrive to this point? Because let's imagine a couple, a female and a male, they go abroad, and then they have surrogacy, and they come back, and they have a document that record the filiazione status. And let's imagine the other case in which we have two women or two men or people that are going abroad and they go back. Is there a difference between these cases? Or, I assume it's easier to detect a surrogacy that has been performed abroad for two women or two men than for a ordinary couple that is a cis heteronormative couple.
How interesting. I've actually never considered the possibility that a family could come home and and sort of indicate that the woman had physically given birth.
Because in Italy, they try to, it used to be like that. They try to hide because sometimes in the document is not shown, and so if the public registrar can see that you are a woman and the other part of the couple is a male, maybe it doesn't control that clearly,
because
but
they have a foreign birth certificate that shows them as the parents.
Yes, but if you are in a same-sex couple, that would be so easy to detect that you had something abroad.
Something happened.
Yes, you left with no kids and now you have a kid. So where did you find the kid? So in that case.
Yeah, I think in Swedish, I mean, I can't be sure about all the different places where surrogacy is performed. I know that in some American jurisdictions that have been very popular with Swedes, it isn't so easy because you just don't have a birth certificate that just says these are the parents. It's more of a court-controlled process. So you have a judgment that says there was a birth mother and she's given rights to this intended mother and so on. Also, I think Swedes are very,
you can say that. Don't worry. You can say that.
Trusting of the government, honest to the government. A very important value for Swedes. So I'm not sure that many people do try to kind of hide what the genetic, background of the child is. But then again, this could be the genetic child of these two people. And then it's just a question of whose womb the child grew in. And I can imagine, I can theoretically imagine that somebody, if a country did issue a birth certificate where these intended parents were the parents on the birth certificate, that does sound a little bit easy. It's not a situation that we've discussed in the family law community in Sweden. I don't think it's that common, but I don't know.
Yes, we have these parental orders and we have these documents that usually show what happened in order to have that kind of affiliation.
Exactly. And they don't go for the requisite amount of time. They go and pick up, or they go for the birth in a few weeks, but they don't go for the kind of
9
year
months.
long that it would be to come back with a child born to you.
Okay. So something has changed, right? Because can you explain what went down in Denmark?
Sure. Well, on the international level, like at the EU level, like at the Council of Europe, there's been a bunch of surrogacy international discussions among experts. What are we going to do about this? There have been conferences and world congresses where people from, for example, European jurisdictions and North American jurisdictions and other jurisdictions in the world have come together and talked about these issues and shared their different sort of regulatory strategies with each other. And a few different drafts and things have gone on. In the midst of this, part of the trend has been that when recognition of parenthood, intended parenthood, isn't recognized by somebody's state, the cases have been brought to the European Court of Human Rights. So that's the regional court that kind of makes sure that these fundamental human rights, like right to family and privacy and so on, are respected. So what we had happen is that Denmark lost a case. There was a situation where a Denmark couple from Denmark went to Ukraine and had entered into a surrogacy contract and came home with, I think it was 2 children.
Yes.
And then it went all the way up through the courts, and at every level, the Denmark the Danish courts denied them the right to be the parents because the surrogate had actually received monetary compensation, had been paid something for this service. And that was a direct statutory violation. You could not approve an adoption if you had paid for the child. It was considered in children's best interest not to recognize those adoptions, even if it was in this child's best interest to have a mother. So the court said no. The family, both the kids and the mother, brought it to the European Court of Human Rights, and the European Court of Human Rights said, no, Denmark, you actually do have to do something for this child to have this mother. Unfortunately, for you, and we understand why your public policy is so, but we have to do something. And so Denmark they could have just fixed the adoption code,
Yeah.
take out that one provision for this situation. That's not what they did. They instead went ahead, and because of all those conversations going on in the world, they actually went ahead and chose a way to legislate this so that a baby would have these intended parents as legal parents from the beginning.
Okay.
Like, it wouldn't have to go through a process of uncertainty with a birth mother that might, regret the decision and so on and so forth. So that's what happened, and it's brand new. It just happened in February of 2024.
So KK against Denmark had an actual impact, and as soon as the KK came out, then Denmark did something.
They did, yeah, exactly. And some creative, legislating with different pathways to do this in a responsible way. The surrogacy has to be in a responsible way.
So can you let me understand, does this law applies to cross-border cases in which I do need to go abroad to perform surrogacy contract and then come back with kids, or can I do surrogacy in Denmark?
Right. They haven't actually gone that far. The new rules focus on recognizing children that are born by surrogacy abroad, and not only after the birth or after the coming home to Denmark. They use the best interest of the child standard to permit Danish family courts to make a decision quickly on who the parent should be in the best interest of this child in the case of a foreign surrogacy agreement, even permitting the court to rule before the family returns to Denmark. So the rules do, however, require that the court look at the best interest of the child, but there's a presumption that, of course, it is in the child's best interest to have a timely recognition of the persons that are going to be their parents. And the court decisions are permitted even if the family does come home to Denmark first and the child is maybe several months old. The court decisions they're allowed to make the order of who are the legal parents retroactive to the birth of the child. So that makes sure that parents have access to things like parental leave benefits that they might need to access in order to be home and take care of a newborn. And in contrast to step-parent adoption, which was the old solution, the new rules allow recognition of the parent-child relationship with the mother or the non-genetic parent, even if the parents have separated. So that was the problem in Sweden, and Denmark knows about that. And or if one parent dies before they have a chance to apply, adoption laws sometimes require that there's a couple. And I'm actually not sure exactly how the adoption rule worked in Denmark before, but I think it was that it had to be a two adoption situation in a step-parent adoption. And if a parent died before they had the chance to apply for that parenthood, they would never have been the parent. But this legislation cleans all of that up to try to kind of meet modern families where they're at. And they do actually, you might be wondering about what happened with the concern with the child trafficking. There is still that concern about mistreatment of women who give birth for surrogacy purposes, and about the children themselves being born to paid surrogates around the world. So to try to address that, the rules require that at least one intended parent be genetically related to the child. So it is something where you can't go abroad and receive a baby that is genetically not related to your couplehood at all, which would sort of be like a traditional international adoption. This is more that the surrogate is required to confirm in a notarized declaration after the birth that she wishes to transfer parenthood of the child to the intended parents, and that one of them is the genetic parent. So it's clearly not, quote unquote, her baby that she's giving away. Yeah.
So we are still following what was said in the case of Valtis Pondrotri against Iceland, I imagine, because in that case we had two non-genetic intended parents, and then we had surrogacy. So I imagine Denmark is trying to follow the European case law in order to address this situation.
Yeah, and yet though, the legislation did go farther than it needed to if you just look at KK versus Denmark.
Okay, but I imagine that this could impact on other Nordic countries. I'm curious now, do you think that other Nordic countries will follow this path or will try to not follow it because they are not involved in KK against Denmark?
Yes, well, okay. I mean, the case applies, of course, to every nation that is bound by the European Convention. So they can't just say they're not Denmark. They have to provide some kind of solution. But the court made clear that allowing step-parent adoption would be enough. So it's only in situations where, like with the Swedish case at the Supreme Court level, where you couldn't follow the current statutory law on adoption because the couple had broken up or that kind of thing. There's a custody fight, that there has to be a different avenue. So they don't have to go as far as Denmark. I haven't heard that anyone is planning to go as far as Denmark. I would almost want to say that Denmark tends to be culturally have an ideal of wanting to recognize different kinds of solutions a little bit, like a little bit of a meeting of cultures, where maybe some of the other Nordic jurisdictions are a little bit more, not isolated, but traditional within their own legal culture a little bit more. I don't know if that's a fair thing to say, but I have not heard anything other than each of the other jurisdictions are still hoping to discourage the use of surrogacy. No one has said, and there have been multiple investigations, multiple questioning internally, nationally in these jurisdictions, should we provide some kind of way to have, for example, altruistic surrogacy if a sister wants to help a brother and his wife, carry a child because they can't do it, the wife can't do it herself. I don't think any of that is actually moving forward in other Nordic countries, but things are happening all the time. So I could be wrong by the time this gets heard by your audience.
Yeah. So we talked about a law that is quite recent in Denmark and is different from the law on surrogacy, because now they are dealing with this new project that is not still a law, that they want to regulate like altruistic surrogacy, but they are like addressing this situation. They are not enforcing this law. They are still discussing about it. There was only like a communication by the government about that, and that's it. So there are two pieces of legislation. One is now enforced since February, and the other one is still a project. So we need to keep looking for it and
keep eyes out for that. I know Sweden has also had these proposals about what to do, but it never has gone as far as Denmark.
Okay, so our time is almost up, so please share where our audience can find you, of course, virtually, and access your works, findings, and research if you can.
Sure. Well, I mean, some of it is on the Just Parent website, and that's justparent.com, but also my website at Uppsala University is accessible. Actually, I've tried it. I've Googled myself at Elizabeth Perry Sweden or Elizabeth Perry Uppsala, and then we get to me, and there's a list of my research publications. Some of them are available by PDF, like my comparison between Sweden and California in the family law and specifically child support area. If anyone wants to read all about California and Sweden and their public policies and their private family law, varsågod. You're welcome to download my 600-page thesis any day.
And you also worked on a chapter about Sweden in the Just Parent Handbook.
Yes, exactly. That's there too.
So it's open access and you can consult it and just Google it, Just Parent Handbook. Exactly. It's available in English and Italian. So thanks, Elizabeth. That was great.
Thanks, Stefania. Nice to get to talk to you.
So, and thanks to our listener. Grazie a tutti per aver ascoltato questa puntata. Ci riascoltiamo nella prossima puntata. Grazie per averci dedicato il vostro tempo. Bye!
Avete ascoltato Famiglia contro l'ordine pubblico, il podcast del progetto PRIN Social Parenthood, genitorialità sociale, indagine sul fenomeno e sui limiti di ordine pubblico. Per conoscere il progetto e tutte le attività che stiamo svolgendo, potete consultare il sito www.socialparenthood.unimore.it e iscrivervi alla nostra newsletter. Si ringraziano i professori Federico Pedrini e Valentina Piccinini, coordinatori delle unità di ricerca. Per la post-produzione ringraziamo Luca Liberatore e Roberta Caccialupi. Infine si ringraziano i dipartimenti di giurisprudenza delle Università di Milano Bicocca e di Modena e Reggio Emilia.